article or piece of a tool that you will need in your corporate minute book diligence is about $80. Attorney's fees, we charge about $1,200, but there are attorney's fees that charge more, attorneys that charge more. The costs of filing service, we use a process filing service, which a lot of attorneys do. They're located in Sacramento. It just makes it easier because sometimes, as we know, we mail stuff to the government and it gets lost. And so we like to pay an extra fee just to make sure that it's hand delivered to the filing window and we can track it, etc. Rush filing, if you're in a rush to get your corporation started for whatever reason, you can pay the state an extra $350 and they will process it within 24 hours. A little bit more on the liability protection that I had kind of spoken about is you have to treat the entity as an independent party. We're hearing a lot right now with the election about Citizens United and corporations being persons, etc. And that's generally how the law sees a corporate entity. They are considered a person. They are to be treated as a separate entity, which can make it very difficult for new business owners, especially those transitioning from having an existing business that was a sole proprietorship to one that's a corporation. It does take a change of mindset and learning that you have to treat this corporation as its separate person. There's no commingling of funds, meaning you can't just pay yourself by taking money from the bank account. You can't just deposit your own money that you want in that bank account. It's really creating the respect of the entity and being able to manage it appropriately. When you do all of that and you follow the formality, then the assets of the shareholders are generally protected. Corporate governance. Corporate governance is a mechanism where the boards and directors are able to direct, monitor, and supervise the conduct and operation of the corporation and its management in a manner that ensures the appropriate levels of authority, accountability, stewardship, leadership, direction, and control. Corporate governance is basically the structure within your corporation that's going to effectuate its control. And we all know, we have heard of board of directors. They exist in all major companies. They exist in nonprofits. The role of the board of directors, in my opinion, is twofold. They are advisory. There's an advisory component and there's an operational component. The board of directors is basically the middleman between the day-to-day operators, the employees, the officers, and the shareholders. So the board of directors is kind of like the meat in the sandwich. They're the ones who are in charge of making sure that they know the mission and the purpose of the company. They are the ones who are in communication with the shareholders, the management. They strategize the direction of the company. They make key decisions concerning major impact, for example, expansion, franchising, anything that is significant to the company will generally be made by the board of directors. On a smaller scale, the board of directors is what will decide what loans will be taken out or made by the corporation. They will decide who the officers will be. They will decide when distributions are made to shareholders, because they're the ones who will generally have to be responsible for the oversight of the budget. They may not necessarily do the day-to-day operations, but they are responsible for the finance, oversight, etc. of the company. And the operational goes into that a little bit, is they provide the oversight to the president, the secretary, the treasurer, the key employees. In a large company, the board does not manage the company. In a closely held corporation, though, often the board is comprised of the same people as are the shareholders, as are the officers. So it's kind of hard to make that distinction when we've got small companies, but it's really important for purposes of keeping memorializations of meetings, that we know that if you are the founder of a company, you're also the shareholder, you happen to be the CEO, and you're also a board of director, you have to wear different hats at different times so that the state knows that you are managing your corporation the way that it should be. This is kind of an example of the different tiers of corporate governance. You have the shareholders, you have the board of directors. This is kind of underneath the board of directors what their roles or duties are. You can have subcommittees, advisory committees, even within the board of directors, audit committees, remuneration committees, or other types of committees. You can have obviously the CEO and management form one or more committees, and then you have the chairman of the board, which is to your left. The board they're the ones that are in charge of the board meetings. They're the ones that are making sure that the boards of directors are meeting or doing what they need to do. And so this is just an example of how some organizations structure their board governance. The duties of directors, like I said before, they approve corporate strategy. These are all the different, I don't have to necessarily enumerate it, but they look and make sure that the company is headed in the direction that it's meant to be headed. That's their goal. They identify risk areas, they plan for new executives, they design compensation packages, they maintain the integrity of published financial statements. They're the ones that hire the CPAs. They're the ones that hire all of these different consultants that will form part of the corporation's operations. They are there to protect the company's assets and their reputation. They represent the interests of shareholders. They're ensuring that the company is complying with laws and codes. Their legal duties in California are mainly they have the duty of care and the duty of loyalty. And the duty of care is similar to that partners. It's a very high standard of care. They're considered fiduciaries, not only to each other, but to the shareholders and to the corporation itself. The duty of loyalty basically means that they can't self-deal. One of the examples is if there's a board of director who maybe has a separate business idea that they are creating on the side, that they're marketing on the side, that they're spending time and they are taking company efforts to create their own idea for their own self-dealing, they are depriving the company of the opportunity to perhaps follow up on that idea if it's something that's along the line of what the company is doing. So the duty of loyalty is there. Board of directors are there for the purpose of making sure that the interests of the corporation and the shareholders are always being met. These duties can be limited by the bylaws of a corporation. So the Corporations Code in California has default provisions for what happens when people don't know how to act within a corporation, what their roles are, what their duties are. All of that can be limited or it can be expanded within the bylaws, which is a written document that the corporation creates, generally at the organizational meeting, that will lay out specifically what the role of all of these different individuals are, what their expectations are, etc. Controlling shareholders have the same duties, especially the duty of care, that the board of directors do. This is most important in situations where we have minority shareholders, where we have maybe one or two shareholders that have a large piece of the pie, and we have some shareholders that have a very small piece of the pie. And because they have a small piece of the pie, they are often very limited in their abilities to actually effectuate change or governance in the corporation. One, because their 5% or their 3% is generally not going to override a controlling shareholder's, 85% or 90%. But also because they're limited in their sellability often of their stock, because it's hard to find someone who wants to acquire a minority interest in the corporation. So under California law, controlling shareholders, those that hold a majority interest in the corporation, have these duties of care to their minority shareholders, meaning they cannot dilute stock even more, so that their minority shareholders go from having 5% to 0.2%, et cetera. So those are the different things that they are restricted. Obviously, these are very general duties and obligations that I'm telling you, and within the law, there's always possibilities, right? But it's very important to make sure that that when you're dealing with minority shareholders, you know what your obligation is as a controlling shareholder. The budget is a big one for board of directors, and they're responsible for making sure that the budget makes sense. And that means reading the financial statements. That means engaging in the conversations that they need to have with the treasurer, the CPA, or any audit committees, so that they know exactly what's going on. Why? Because they have to turn around and provide this information to their shareholders. They are considered to be responsible for the information and for the activities of the corporation. Wages. Wages is important, especially in a closely held small corporation. Direct liability for wages, basically unpaid wages, is going to pass through from officers to directors and even potentially shareholders, if they happen to be the same people, obviously. So if employees aren't getting paid, or if employees are being withheld pay, and that withholding isn't being used for what the intended withholding is, paying taxes, putting into 401ks, whatever it may be, the officers and directors will generally have personal liability for that. So that's important to always know when you are looking over budgets, when you have an HR individual, when you have a treasurer, to really make sure that you know exactly what's going on with payroll. And this is an area that companies always get hit with, because they don't pay attention closely enough to the wage issues. They have employees that maybe aren't doing what they should be doing in terms of managing it appropriately, and it just takes one claim often for it to especially make a big impact on a company that's starting up. Errors and omission insurance for boards, that does exist. It can be obtained for private corporations. It's good when the board is not directly involved in the day-to-day operations. When you are directly involved, you often can't separate that liability, specifically because you are the one who is making the paychecks. You are the one who is signing off on this and doing all of that. So as a corporate entity gets bigger, for the board of directors, it is important to consider having an errors and omission insurance, so that at least if there is a claim made, it can be stopped at a certain level. Some of the disputes that may arise with owners, shareholders, and the issue again of personal liability. So ownership disputes. I've always said, and I think most attorneys would agree, partnerships generally don't work in the form of how we know them as partners, right? They work best and they endure the test of time when the partners generally will segregate their duties and everyone knows exactly what the other person is doing. That way, one person who may be doing more doesn't feel left out. Doesn't feel like they're putting more effort into the company than another owner. And this is very apparent, and I have a lot of clients that come to me, especially small businesses, who have taken on investor partners, right? They really are investors, but they've entered into some type of a partnership agreement where there's an individual that comes along and says, I've got $50,000. I want to help you start your business. Here's the deal. I'll put the money in. You run the restaurant, and we'll divide the proceeds 50-50, and it'll be great. Well, sure enough, not that long passes, and the person that's been waking up at 5 o'clock in the morning to go to the restaurant and prepare the food, and has been there until 10:30, and manages the employees, and does everything with a bank account, starts to feel resentful of the person who is not present, right? Because the investor portion of it was never really made clear. The investor also at some point in time wants their money and wants a return on their money, and usually wants a very quick return on their money. And so when they don't see that, they start to put pressure on the person that's running or operating the business when they don't even know what's going on there. So there's a lot of problems that can arise when we have partners that don't understand what their roles are. It's fine to take on investors. Companies do it all the time, but true investors work very differently than the way that a partner will work. True investor will make an investment in an idea, in a company, and they will generally wait until that company is established and grows, etc., before they expect to see any return on their investment. And they go in knowing that there's a risk that there may not be a return at all. A partner is someone who should be actively engaged in the day-to-day operations of the business. It could be someone that's handling the books, doing the marketing, doing the publicity, someone that has a specific role. So it's important to avoid ownership disputes, that the owners know exactly what each person's going to be doing, and that they receive the adequate compensation for what they're doing. So if someone is running and operating the business and they're spending 80 hours a week there, they should be accurately and adequately compensated for that, without consideration of what happens, in terms of dividing up the proceeds. I've found that that's usually how these companies end up lasting the longest, is when the owners are adequately compensated for what they're actually doing. Buy-sell agreements. Buy-sell agreements, there are several agreements that every business owner should be familiar with. I'll just focus today on buy-sell agreements because I think that they're really, really important. And basically, the buy-sell agreement is an agreement between the corporation and its owners. And the buy-sell agreement is there to help resolve disputes when there's a situation of an unexpected circumstance that may arise, or if it's to be expected, just a natural course of the business. For example, someone may retire. Someone may decide that they don't want to be in business with you anymore. Someone may have a health concern that prevents them from continuing to participate actively in the business. So the buy-sell agreement will generally contain a myriad of agreements between the owners. And one of the important provisions that can be contained within a buy-sell agreement is that who will buy and who will sell their portion of the business when one of several possible events happens. When you start a business with your team, you intend on going into business with that team. You may not intend on going into business with their spouse or their 5-year-old child or their parents or whoever they may have picked to be their heir or beneficiary. So if someone passes, which it's not if, it's when someone passes, it's important to know exactly what's going to happen with their interest in the corporation. As an example, right now I have an LLC entity that was created many, many years ago to manage real estate by a couple. And they acquired several pieces of property all around the county, probably about 10 multi-unit buildings. Well, they wanted this to stay within their family, and their idea was that eventually their kids and their kids' kids could all benefit from this great income source that they lived off of for their lives. Well, Grandma and Grandpa are no longer with us, and Grandma and Grandpa had 7 kids. And, each of those kids has 9 point whatever percent is in the LLC. Well, those kids are now in their 70s and 80s. Several of them have passed, and they have either transferred their interests through trusts or other mechanisms to their heirs. So now we have probably about 23 owners of very small fractions of interests in this LLC, which holds these properties. Well, the problem is you have great-great-grandkids that don't live here, that don't understand, that they just want their money. So you have people who are managing it more, who care more. So we can run into a lot of problems in succession when you don't plan for what's going to happen when an owner leaves the company. So one of the key parts of a buy-sell is going to be who's going to buy whose shares, at what price, and under what terms. And it's important to create a buy-sell agreement when everyone gets along, because when people don't get along, you're not going to sign on anything. And it's important to create that at the outset, or at least revisit it regularly, because obviously circumstances change. Your company will start from being a small company to hopefully being a very large company, and we're going to be talking about different values, et cetera. You may have different shareholders. So it's important to consider this as something that you may need to do right after you incorporate, if you have any partners, shareholders, et cetera. What are the next steps for you guys? So some of the next steps for you are going to be to obviously get your ideas ready, get your business going, get your business plan, get all of your funding in place. And once you're ready to start, it's good to, one, figure out who is going to be an owner in your company and who's going to be an investor. Who's someone that's actually going to take a piece of the pie versus who's someone that's going to sit back and maybe wait until you have been very successful to get some type of return on an investment. Investors should not be there for long periods of time. Investors have a short-term life. They're there to put some money in, hopefully get some money back, and as soon as they get back, your goal is to try to get them out of the picture, because you want to be able to always have full control over your company. And the longer an investor sits there, the greater the risk is that there's going to be a dispute down the road over the governance, over the operation, over how much you're spending. How much you're spending limits how much the profits you get, which limits how much they get. So it's really important to have those clear lines designated. Meet with a certified public accountant, meet with an attorney, create your board of directors, hire your officers, which will generally in a small company be you, keep the corporation current, pay the taxes, the registrations, maintain the corporate minute book, maintain the corporate formalities, and ultimately get ready for success. So I just wanted to thank you, and I want to open it up for any questions if there may be. If there isn't any questions, because I know that we're videotaping this, my information is, I left some sheets here that you guys can grab, but I'll head to let me see if I can head to the first screen. My information's here, my email and my telephone number. I'm in lovely Santa Paula, and I'd be happy to meet with you, answer any questions that you may have about formalizing your legal entity or how to stay out of legal trouble once you're a business. That's it. Thank you.
All right. Well, good morning. I know it's kind of early, so hopefully you've had your coffee, because I'm going to do my best not to put you asleep. My name is Brent Rinke. I'm a corporate law partner at Music Peeler and Garrett, work out of our Westlake Village office. And I've worked with a lot of entrepreneurs and startups over the years, do a lot of venture capital, private equity, M&A transactions, and helping set up companies. And Martin had asked me to come here this morning and talk a little bit about venture capitalism. What I wanted to do first of all is kind of give you more of an overview of the process, maybe briefly explain to you what a venture capitalist is, and then toward the middle to end of the presentation, I'll get into the technical language, but honestly, it's kind of going to be Greek to you, and I'll do my best to explain it in the simplest terms I can. But I think it's important really to understand the process and how you prepare yourself for the process to have the best chance of succeeding at getting the interest of a venture capitalist. First of all, when I talk about venture capitalists this morning, I don't just mean in the truest sense of the word. You really will run into these exact same issues when you try to raise money from, say, an angel network, which is basically a group of wealthy individuals that invest in companies in smaller amounts of money than venture capitalists will. But you will come across the exact same issues and terminology because in most cases they're really sophisticated individuals that will view the investment like a venture capitalist and will want what's called preferred stock. And that's some of the language that I'll talk about in a bit here. But as you get into this process, I think in a good way to kind of wrap in what it sounds like some of the prior discussions have been about, it's really kind of important to understand that the key term is that you never get a second chance to make a good first impression. And I think it's really important when you think about venture capital in that way. You're going to be approaching these people who get hundreds of business plans, probably a month. And I'll talk a little bit about the best way you get in front of them. But you want to approach them and do it in a way where there are the fewest amount of issues that may come across their desk. And because the more issues you have, the less likely they're going to be interested in pursuing something with you. They're going to go path of least resistance. If they look at your company, it looks really interesting, but they look at 5 others and they have a similar amount of interest, but your company has a bunch of issues, and I'll talk about what some of those could be, they're honestly going to move on because it's going to take a lot of more effort and time to address those issues and to undo the issues you've created. And honestly, it's going to slow the process down, which typically ends up meaning there's a less likelihood you're going to end up getting funding from that group, and it's just more time and effort on their part, and they're probably not going to pursue it. So one of the things I would suggest, and this is what's great about what you guys are learning through this event this weekend, is educate yourself. From what I'm going to talk about, from choosing an entity, capitalization, setting up your stock option plans, IP issues, knowledge is power. And the more you know about this process, the fewer mistakes you're going to make, and the better chance you're going to have of succeeding in building your company, getting outside financing into your company, and ultimately getting to the end of your business plan and being successful. So, again, approach it from that perspective. But let's really quickly touch upon some of the areas that you want to think about before you start thinking about going out and raising capital. And again, some of this is stuff in much more detail has been talked about already this weekend, but choosing an entity. Just make sure that you really think that through and set it up properly. And let's just, for example, if you pick a corporation versus an LLC, you want to have the right language in the articles of incorporation. You want to have the right language in your bylaws, and in particular the indemnification language that relates to board of directors. Because if you start bringing in outside people, and in this case it's going to be the investor, will probably have a representative on your board. They're going to want to make sure you have that kind of language in your bylaws and in your articles. IP issues, we were just talking about this a little bit. When you are using outside third parties to help you build your technology or contribute in any way to your company, and they're not an employee, if you don't have a written contract with them that says basically whatever I do in the course of providing ideas, intellectual property, or other things to your company that you've just formed, that individual will own those ideas. And so one of the first things a venture capitalist or any investor is going to do is, do you have those kind of contracts in place? And if you don't, you've got an issue. suddenly you're going to slow the process. You're going to have to go back and try to figure out how to undo that issue you've created for yourself. Setting up your stock option plans and capitalizing yourself the proper way. When you do option plans, there's certain number of an option pool size that you want to create that they expect to see as an investor, and they want to see it because they want to have your employees and outside representatives adequately incentivized. So that's another thing that they will look for, is whether or not you have an option plan. Is it capitalized property, or do you have the right size option pool in place? So again, this is just some of the basic things that you're going to be wanting to look at and make sure that you've got in place and done the right way before you start down this process. Because if you don't, again, you're going to have that negative first impression and you can't undo it. So venture capitalist. Let's start with both groups. Angel investors, I mentioned, are wealthy individuals that basically get together, oftentimes more of an informal basis, and look at deals and decide if they're going to invest. They're good for deals, $50,000, maybe up to $500,000. Sometimes a couple of angel groups will get together and they may go up to $750,000 or $1 million. So smaller amounts of money. Beyond that, you kind of got this area where it's really difficult to raise capital. I'll be honest with you. It's about $1 million to $3 million. A lot of venture capitalists won't look at deals unless they're at least $3 million plus that you want. And the reason for that is it takes just as much time and effort for them to put money into a deal that's a $3 million deal as one that they're trying to raise $10 million on. And they've got a certain amount of money that they've got to place into the market, because what a venture capitalist is basically what is a fund. They get money from institutional investors, large funds and sometimes individuals, and they manage it, and they have to place it because their investors in those funds expect a certain amount of return. The only way they're going to get the return is if they put that money into the market. So it's when you get into that area of $1 to $3 million, it's a difficult place to be because of that very issue. But that's basically what is kind of the difference between a angel investment group and a venture capitalist. So what do venture capitalists look for? What do angel investors look for? It's pretty much the same thing for both those types of groups. Well, they want to look at the market. And they look at the market and will determine, is it big enough? Because unless the market itself is big enough and you can grow a company to 40, 50, 60, $100 million a year, they're not going to have an opportunity to get the return on investment that they need. So they look at the market size. The next thing they look at is what you're trying to do. Are you having to create a new market for it? Or is this something that already exists and you've got disruptive technology that you're going to put into it that is really going to shake things up and separate you from others in that same market? If it's a new market you have to create, that increases the risk because it's going to take a longer period of time. And the VC will look at that. Or is it a small market that you think has potential to really grow because you've got this interesting technology? If that's the case, again, you've got a situation where it's going to take a longer period of time to build that market, and the VC will look at it and factor that into their investment. They'll factor it in from valuing your company. They'll look at it from the perspective of how long is it going to take for you to basically exploit that market, build the size of the market. And so, again, that'll come into play in their discussions with you on whether or not they're going to want to make an investment. Management, and that's what we call the M&Ms of investing. Preferably, venture capitalists and angel investors will want an experienced management team. Well, obviously, when you're a startup, oftentimes you're a group of people that have never done this before. So you look at that and go, well, Brent, that's great. They want an experienced management team, but how is that possible? You're kind of a chicken before the egg. If I don't go through this process, I can't be experienced and then come back and do it again. And there are those people, like Martin, that have done this before. So he has a leg up when he's going out to raise capital. But there's ways you can address that issue, even as a group of people that have never been through this process. Surround yourself with people that have, whether it's as a board member, whether it's advisory board people, or just people that are advising you on it. So I'm not saying that your management of the company has to be experienced at this, but surround yourself with people that have that experience, because you can leverage their experience and present that to these angel investors and venture capitalists to give you credibility that you have a management team or you have a group of advisors that, that are experienced. And that'll give them a comfort level that you're going to have a better chance of understanding how to execute on your plan and basically putting the plan together and doing it in such a way that you're going to be successful. So those are some of the ways you can address the management side of this. As we go through the handout here, what is the ROI? Again, that comes back to market size. The venture capitalists certainly want a certain degree of return on their investment, and so do angel investors. I mean, they want to get their investors 25, 30, 40% return. Well, the reality is that they're going to invest in certain companies, a group of companies that don't succeed, which means they got a 0% return on their investment, which means the ones that do succeed have to be really successful and to come up with this 25, 30, 40% return on investment. So the only way they're going to get there is if there's a significant market size for their investment to really be realized at those ROIs that they need to bring back to their investors. So again, market size. All this is stuff you should be thinking about when you're building your business plan. If you're creating something and you think that, hey, I can build this into a $5 million a year company and the market size is $50 million, don't plan on getting venture capital money, and unlikely you'll get even angel money. You're going to have to create some type of lifestyle company out of that if you really want to pursue it, and it's going to have to be friends and families funded if you still want to pursue it. But keep that in mind when building these and ideas and coming up with these business plans. It's got to be a decent size, or at least a realistic potential for a good size company in a market that is fairly significant. As far as size, I mean, honestly, you should be looking at markets that have, 500 million plus as a market size potential. If you're going to really go after institutional money. Yeah, I'm not saying you have to do that. I mean, companies are finding ways to fund themselves outside of the traditional routes of venture capitalists and private equity. But just as a rule, a general rule of thumb, and every rule has an exception to it, you got to be looking at a fairly sizable market like that. Choosing a venture capitalist, I mean, really critical. There are a lot of venture capitalists out there, but you want to choose the one that has industry knowledge in what you're doing, because you really got to look at a venture capitalist and angel investors from the perspective it's not just money, it's knowledge, it's contacts, it's got to be that value add that they bring to the table. So this is where the contacts you have with advisors, with professionals, accountants, lawyers, and others that can help you identify the VC out there that can really bring that value add, not just money, but industry knowledge. And if they don't have industry knowledge, it's unlikely they're going to have any interest in what you're doing anyway, and you're going to waste a bunch of time pursuing venture capitalists that have no interest from the get-go. So, I think, again, I talked about surrounding yourself with knowledge, people with knowledge. This is where the value comes into play. It's like minimize the spinning of the wheels you're going to do and find people that understand the process, are connected in the industry, that can help you get to the right people directly. And then you'll find out soon enough whether or not they have an interest in what you're doing. But even if it's a negative feedback or critical feedback, learn from it. I mean, modify your plan, modify what you're doing with your company or your business plan or your vision, and take it from that perspective. You're going to get a lot of pushback and criticism and questions about what you're doing. But I've always told people, I mean, try not to be offended by it, but learn from it, because that is invaluable feedback that when you take it in, rethink what you're doing, and then go back out again to, say, another venture capitalist in that industry, then you're going to show them that you've really thought this through and maybe get a better response from somebody else that you approach. So, again, you've got to be comfortable with criticism and hard questions about what you're doing, both from VC community, but also your advisors and others, but learn from it. It really can be invaluable. Get a hold of venture capitalists. It's really, the referrals are going to be your best source of getting into a VC. Again, as I noted, they get hundreds of business plans a month. And if it's a cold call, so to speak, you just email it to some VC that you read about and it looks like they have industry experience, the chances of you getting their attention are de minimis. This is, again, where your professionals, your advisors, and others who are familiar with the industry can be incredibly helpful. And realize this is where the value comes in. When I have a client that I'm working with and they ask, hey, Brent, do you have any contacts in the VC community? I honestly won't refer them to contacts I have unless I'm comfortable that they have a good chance of succeeding, or if they're ready to be presented to those people, because I'm putting my reputation on the line. And this is the same for any other advisor, or whether it be an accountant or a board member or an advisory board member. Because when a VC gets a referral from me or for somebody else, they kind of look at it as part of a vetting process. And if it comes from me, they go, okay, well, it came from me, it came from Martin, it came from somebody that's a trusted source. And usually when I get something from that person, it should be of interest to me to at least take a look at. So, we're kind of almost the first screen to make sure the business plan is written properly, that it's been vetted and written fairly well, and there is an opportunity for something to be successful here. So that's why the venture capitalists look at the referral source as such a key component of this, because they'll accept it and they'll look at it because they think it's already been vetted to some degree. So that's is definitely really important. All right, so that's kind of some of the background leading into things you should consider before you go out and try to raise capital. Being prepared for the process, making sure that you've vetted yourself, that you're going to hopefully get at least some initial positive feedback, and not have this negative connotation because you forgot to address some of the basic issues. So then you get into, and I know this is a lot of Greek kind of language to people, you get into some of the specifics of what is preferred stock and what are some of the terms you're going to start having thrown at you. So this is in the handout and it's summarized, so take a look at it when you have a chance. And we try to do it in such a way that it's as basic as you can make it. But I'll go through this a little bit and discuss it, and then if people later have questions about it, we can talk about it a little bit further. But let's first of all explain the difference between common and preferred stock. Common stock basically doesn't necessarily have any what we call extra rights, preferences, and privileges. It basically has certain voting rights, certain rights under the corporate code, certain rights to dividend, right to elect board members, but that's kind of the basics of what it is. Preferred stock is something that invariably you will see that venture capitalists and most angel investors will want. And basically, it adds certain rights, preferences, and privileges that protect them, protect their investment, and give them priority over common stockholders, which is going to include the founders of the company. That's just the way it is. They view the fact that it's your company, you believe in it, great, but you're taking our money. You're telling us that all these great things are going to happen with it, but we believe that we have a higher degree of risk and we want greater opportunity for return on our investment, and we want greater protection for our investment. So that's what all these terminology matters are about. So the first one's a dividend preference. Preferred stock basically has two different types of dividend preferences. One which is called mandatory cumulative, which basically means that the stock is receiving a dividend on an annualized basis at a certain percentage that accrues on the books of the company. The deals that we do, I really try to negotiate away from mandatory cumulative, and we basically try to negotiate what is the second type of dividends, which is known as when and if declared. And essentially all that says is if the board declares a dividend, the preferred shareholders get it in preference to the common. Now, the board typically doesn't declare dividends in a company that's not profitable. So the when and if declared dividends don't take place. There's no dividend accruing generally. And those are typically the types of dividends that we negotiate into deals. Then there's a thing called a liquidation preference. And conceptually, you would hear liquidation, you're thinking, well, then that only comes into play when the company liquidates itself. And that is one of the events that causes the liquidation preference to come into play. And what a liquidation preference is typically that you get the investor gets their money back, plus if there had been any dividends declared, if it were when and if declared dividend, or if it's mandatory cumulative, they get their dividends paid before common stock gets anything. Now realize that the creditors of a company, whether they're secured or what we call unsecured, are going to get paid back first. the equity owners of our company are going to get nothing until the creditors, trade creditors, secured creditors, everybody gets paid off first. But keep in mind, when you negotiate, liquidation preference also means and is defined as a sale of the company. So it's not just when the company goes under, by bankruptcy, whatever it might be, it's also when the company is sold. So this liquidation preference comes into play there. So a preferred shareholder on the sale of the company will get their money back, and then if there's any dividends that they're entitled to, they would get paid those. The other caveat that comes into play is something called a participating preferred. And what that means is that if it's a participating preferred, they get their money back, and if they make the election, they then get to participate in the balance of the proceeds of the sale based on their ownership percentage. So they really, and we call it, and this is how we negotiate it, we think that's the double dipping. Either you should take your liquidation preference, get your money back, plus whatever the dividend is, or just elect to participate as an owner of the company. But if you're participating preferred, and this is where the details of these deals really come into play, you get both. And so we take the position as counsel for the company that that's a double dip. And it's not, it's unfair for the founders or the rest of the company, and you should only get one or the other. So it's a negotiated term, and you see how it comes out. The next one is a redemption. It really comes into play in two contexts, but it's really more prevalent in one than the other. So the first one is the company has a right to redeem shares on certain triggering events, whether it's over a period of time, at a certain value, or whatnot. You don't see that very often, especially if you're negotiating deals with a venture capitalist. They want control over when they have to sell their shares. But they also, as preferred shareholders, have a right to force the company to redeem their shares at a certain point in time. And when that comes into play, typically is when, and the term of art is you kind of have a company that's a living dead. It's just sitting there. It's not really growing, but it's maybe slightly profitable. The preferred shareholders at some point may just say, this is going nowhere. We want out, and we're going to exercise our redemption right. And then that's when that comes into play. There's limitations on the company's ability to do that based on the corporate code, limitations that are imposed. But again, just realize that as a right that does exist. There's a thing called conversion rights, and basically, so you've got preferred stock, and there are times where that preferred stock either can or has to be converted into common stock, back into common stock. Typically, one of the triggering events for that conversion to be automatic is if the company happens to be really successful and there's a public offering. Upon public offering, those rights, those preferred shares convert to common based on the conversion price, and we'll talk about that in a second. So that's typically where there's an automatic conversion. The preferred always have a right to convert, but as a practical matter, they won't until there's that type of event. The next thing is a thing called anti-dilution protection. So when a preferred shareholder invests in a company, they invest at a certain per share price. And this protection basically says, and let's just pick a number. It was a $25 million valuation of the company that they invested in at. And let's say that you do another round of financing, and you want to do what we call a down round, that for whatever reason the value of the company has dropped. And let's say it's only worth $10 million now. And so the per share price obviously is going to be less than it was at $25 million.